Chapter 11, Quorum and Order of Business and Related Concepts. 40. Quorum. As indicated in 3.3, a quorum in an assembly is the number of members, see definition 1.4, who must be present in order that business can be validly transacted. The quorum refers to the number of members present, not to the number actually voting on a particular question. Rules pertaining to the quorum. Number of members constituting a quorum. Depending on the organization and the provision it adopts in this regard, the number of members constituting a quorum may vary. As discussed below, most voluntary societies should provide for a quorum in their bylaws, but where there is no such provisions, the quorum, in accordance with the common parliamentary law, is as follows. 1. In a mass meeting, the quorum is simply the number of persons present at the time, since they constitute the entire membership at that time. 2. In organizations such as many churches or some societies in which there are no required or effective annual dues and the register of members is not generally reliable as a list of the bona fide members, the quorum at any regular or properly called meeting consists of those who attend. 3. In a body of delegates, such as a convention, the quorum is a majority of the number who have been registered as attending, irrespective of whether some may have departed. This may differ greatly from the number elected or appointed. 4. In any other deliberative assembly with enrolled membership whose bylaws do not specify a quorum, the quorum is a majority of all the members. To accomplish their work, voluntary societies that have an enrolled membership generally need a provision in their bylaws establishing a relatively small quorum, considerably less than a majority of all the members. In most such organizations, it is rarely possible to obtain the attendance of a majority of the membership at a meeting. Sometimes the specification of a quorum is based on a percentage of the membership, but such a method has the disadvantage of requiring recomputation and may lead to confusion. For example, when the secretary or other officer who is in a position to certify as to the current number of members for purposes of the percentage calculation is absent. There is no single number or percentage of members that will be equally suitable as a quorum in all societies. The quorum should be as large a number of members as can reasonably be depended on to be present at any meeting, except in very bad weather or other exceptionally unfavorable conditions. Note on procedure in changing the quorum provision in bylaws. If it becomes necessary to change the quorum provision in a society's bylaws, care should be taken, because if the rule is struck out first, the quorum will instantly become majority of the membership, so that in many cases a quorum could not be obtained to adopt a new rule. The proper procedure is to strike out the old provision and insert the new provision, which is moved and voted on as one question. Quorums and boards and committees. In a committee of the whole, or its variations, see Chapter 52, the quorum is the same as in the assembly unless the rules of the assembly or the organization, that is, either its bylaws or its rules of order, specify otherwise. In all other committees and in boards, the quorum is the majority of the members of the board or committee unless a different quorum is provided for, A, by the bylaws, in the case of a board or standing committee that the bylaws specifically establish, or B, by a rule of the parent body or organization, or by the motion establishing the particular committee, in the case of a committee that is not expressly established in the bylaws. Proceedings in the absence of a quorum. In the absence of a quorum, any business transacted, except for the procedural actions noted in the next paragraph, is null and void. But if a quorum fails to appear at a regular or properly called meeting, the inability to transact business does not detract from the fact that the society's rules requiring the meeting to be held were complied with and the meeting was convened, even though it had to adjourn immediately. Even in the absence of a quorum, the assembly may fix the time to which to adjourn, Chapter 22, adjourn, Chapter 21, recess, Chapter 20, or take measures to obtain a quorum. Subsidiary and incidental motions, questions of privilege, motions to raise a question of privilege or call for the orders of the day, and other motions may also be considered if they are related to these motions or to the conduct of the meeting while it remains without a quorum. A motion that absent members be contacted during a recess would represent a measure to obtain a quorum. A motion to obtain a quorum may be moved as a main motion when no business is pending, or as a privilege motion that takes precedence over a motion to recess, Chapter 20. Such motions are out of order when another has the floor, must be seconded, are debatable except when privileged, are amendable, require a majority vote, and can be reconsidered. Motions to obtain a quorum are similar to a call of the House, which can be obtained in assemblies having the power to compel attendance. See below. The prohibition against transacting business in the absence of a quorum cannot be waived even by unanimous consent, and a notice, 1044 through 51, cannot be validly given. If there is important business that should not be delayed until the next regular meeting, the assembly should fix a time for an adjourned meeting and then adjourn. If, instead, the members present take action informally in the absence of a quorum, they do so at their own risk. Although the assembly can later ratify their action, 1054 through 57, it is under no obligation to do so. If a committee of the whole finds itself without a quorum, it can do nothing but rise and report to the assembly, which can then proceed as described above. A quasi-committee of the whole, or a meeting in informal consideration of a question, can itself take any of the actions permitted in assembly in the absence of a quorum, but a quasi-committee of the whole is thereby ended. See Chapter 52. Manner of enforcing the quorum requirement. Before the presiding officer calls a meeting to order, it is its duty to determine, although he need not announce, that a quorum is present. If a quorum is not present, the chair waits until there is one, or until, after a reasonable time, there appears to be no prospect that a quorum will assemble. If a quorum cannot be obtained, the chair calls a meeting to order, announces the absence of a quorum, and entertains a motion to adjourn or one of the other motions allowed as described above. When a chair has called a meeting to order after finding that a quorum is present, the continued presence of a quorum is presumed unless the chair or a member notices that a quorum is no longer present. If the chair notices the absence of a quorum, it is his duty to declare the fact, at least before taking any vote or stating the question on any new motion, which he can no longer do except in connection with the permissible proceedings related to the absence of a quorum, as explained above. Any member noticing the apparent absence of a quorum can make a point of order to that effect at any time, so long as he does not interrupt a person who is speaking. Debate on a question already pending can be allowed to continue at length after a quorum is no longer present, however, until a member raises the point. Because of the difficulty likely to be encountered in determining exactly how long the meeting has been without a quorum in such cases, a point of order relating to the absence of a quorum is generally not permitted to affect prior action. But upon clear and convincing proof, such a point of order can be given effect retrospectively by a ruling of the presiding officer subject to appeal. Chapter 24. Note: what happens to a question that is pending when a meeting adjourns because of the loss of a quorum or for any other reasons is determined by the rules given in 21.7. If such a question, however, was introduced as new business and it is proven that there was already no quorum was introduced, its introduction is invalid, and to be considered at a later meeting, it must again be brought up as new business. Back to reading. Call of the House. In legislative bodies or other assemblies that have legal power to compel the attendance of their members, a procedure that can be used to obtain a quorum, if necessary, is the motion for a call of the House. This is a motion that unexcused absent members be brought to the meeting under arrest. A call of the House is not applicable in voluntary societies. Assemblies in which there may be occasion to order a call of the House should adopt a rule governing the motion and providing that if 1/3, 1/5, or some other number less than a majority of the members or members elect are present, they can order a call of the House by a majority vote. When a quorum is not present, the motion should take precedence over everything except a motion to adjourn. Chapter 21. If the rule allows the call to be moved while a quorum is actually present for the purpose of obtaining a greater attendance, the motion at such times should rank only with questions of privilege, should require a majority vote for adoption, and, if rejected, should not be allowed to be renewed while a quorum is present. When a call of the House is ordered, the clerk calls the roll of the members, then calls again the names of the absentees, in whose behalf explanations of absence can be made and excuses can be requested. After this, no member is permitted to leave, the doors are locked, and the sergeant-at-arms, chief of police, or other arresting officer is ordered to take into custody absentees who have not been excused from attendance and bring them before the House. He does this on a warrant, signed by the presiding officer and attested by the clerk. When arrested members are brought in, they are arraigned separately, their explanations are heard, and, on motion, they can be excused with or without penalty in the form of a payment of a fee. Until a member has paid such a fee assessed against him, he cannot vote or be recognized by the chair for any purpose. After a call of the House has been ordered, no motion is in order, even by unanimous consent, except motions relating to the call. Motions to adjourn or dispense with further proceedings under the call, however, can be entertained after a quorum is present, or after the arresting officer reports that, in his opinion, a quorum cannot be obtained. An adjournment terminates all proceedings under the call of the House.